His instinct under adequate pressure is always to overrule anything repugnant to him that a legitimate legislative assembly may have done. In this instance, had the case been one of first impression, nothing would have been easier than to have nullified the Sherman Act as an unreasonable exercise of the police power, as judges had been nullifying statutes of which they disapproved for a couple of generations previously. But the case was not one of first impression. On the contrary, the constitutionality of the Sherman Act had been so often upheld by the judiciary that the Chief Justice himself admitted that so long as Congress allowed him to use his reason, these "contentions were plainly foreclosed." Therefore, for him the path of least resistance was to use his reason and, as a magistrate, to amend a statute which Congress ought to have amended, but had unreasonably omitted to amend. Such was the final and logical result of the blending of judicial and legislative functions in a court, as they are blended under the American constitutional system. Nor is it unworthy of remark that the Chief Justice, in abstaining from questioning the constitutionality of the act, expressly intimated that he did so because, by the use of his reason, he could make that reasonable and constitutional which otherwise might be unreasonable and unconstitutional. The defendants pressed the argument that destroying the freedom of contract, as the Sherman Law destroyed it, was to infringe upon the constitutional guarantee of due process of law. To this the Chief Justice rejoined, "But the ultimate foundation of all these arguments is the assumption that reason may not be resorted to in interpreting and applying the statute. As the premise is demonstrated to be unsound by the construction we have given the statute, these arguments need no further notice." Should Congress amend the Sherman Act, as it seems somewhat disposed to do, by explicitly enacting the rule of the Trans-Missouri case, a grave issue would be presented. A trial of strength would then be imminent. Nearly a century ago Jefferson wrote to Spencer Rowan, "The Constitution on this hypothesis is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please." And however much we may recoil from admitting Jefferson's conclusion to be true, it none the less remains the fact that it has proved itself to be true, and that the people have recognized it to be true, and have taken measures to protect themselves by bringing the judiciary under the same degree of control which they enforce on other legislators. The progression has been steady and uniform, each advance toward an assumption of the legislative function by the judiciary having been counterbalanced by a corresponding extension of authority over the courts by the people. First came the protest against Marbury and Madison in the impeachment of Chase, because, as Giles explained, if judges were to annul laws, the dominant party must have on the bench judges they could trust. Next, the Supreme Court of New York imagined the theory of the police power, which was adopted by the Supreme Court of the United States in 1837. But it stood to reason that if judges were to suspend constitutional limitations according to their notions of reasonableness, the people must have the means of securing judges whose views touching reasonableness coincided with their own. And behold, within 10 years, by the Constitution of 1846, New York adopted an elective judiciary. Then followed the Dred Scott case, the Civil War, and the attack on legislative authority in Hepburn v. Griswold. Straightway the court received an admonition which it remembered for a generation. Somewhat forgetful of this, on May 15, 1911, Chief Justice White gave his opinion in the Standard Oil case, which followed hard upon a number of state decisions intended to override legislation upon several burning social issues. Forthwith in 1912 the proposition to submit all decisions involving a question of constitutional law to a popular vote became an issue in a presidential election. Only one step farther could be taken, and that we see being taken all about us. Experience has shown, in New York and elsewhere, that an election, even for a somewhat short term, does not bring the judge so immediately under popular control that decisions objectionable to the majority may not be made. Hence the recall. The degradation of the judicial function can, in theory at least, go no farther. Thus the state courts may be said already to be prostrate, or likely shortly to become prostrate. The United States courts alone remain, and should there be a struggle between them and Congress, the result can hardly be doubted. An event has recently occurred abroad which we may do well to ponder. Among European nations, England has long represented intelligent conservatism, and at the heart of her conservatism lay the House of Lords. Through many centuries and under many vicissitudes, this ancient chamber had performed functions of the highest moment, until of late it had come to occupy a position not dissimilar to that which the Supreme Court of the United States yet holds. On one side it was the highest legal tribunal of the empire, on the other it was a non-representative assembly, seldom indeed originating important legislation, but enjoying an absolute veto on legislation sent it from the Commons. One day, in a moment of heated controversy, the Lords vetoed a bill on which the Commons had determined. A dissolution followed, and the House of Lords, as a political power, faded into a shadow, yet, notwithstanding this, its preeminence as a court has remained intact. Were a similar clash to occur in America, no such result could be anticipated. Supposing a president, supported by a congressional majority, were to formulate some policy no more subversive than that which has been formulated by the present British cabinet, and this policy were to be resisted, as it surely would be, by potent financial interests, the conflicting forces would converge upon the Supreme Court. The courts are always believed to tend toward conservatism, therefore they are generally supported by the conservative interests, both here and elsewhere. In this case a dilemma would be presented. Either the judges would seek to give expression to preponderant popular opinion, or they would legislate. In the one event they would be worthless as a restraining influence. In the other, I apprehend, a blow would fall similar to the blow which fell upon the House of Lords, only it would cut deeper. Sharing the House of Lords of political power did not dislocate the administration of English justice, because the law lords are exclusively judges. They never legislate. Therefore no one denounced them. Not even the wildest radical demanded that their tenure should be made elective, much less that they should be subjected to the recall. With us an entirely different problem would be presented for solution. A tribunal, nominally judicial, would throw itself across the path of the national movement. It would undertake to correct a disturbance of the social equilibrium. But what a shifting of the social equilibrium means, and what follows upon tampering with it, is a subject which demands a chapter by itself. End of chapter 3. American Courts as Legislative Chambers.